Patent Process and Issues to Consider, prepared for and presented at the 2014 Square One Entrepreneurship Training Program. Square One is a program of the Center for Emerging Technologies. CET is an affiliate of the Cortex Innovation Community. Square One is funded in part by the Missouri Technology Corporation.
Thanks, ML, and thanks everybody for coming out tonight. ML asked me to cover in general the patent process, issues to consider. I was an in-house counsel. You'll see Brian and David afterwards. They're outside counsel, and you can tell because they're wearing suits and sport coats. But I'm going to try to give you that in-house counsel perspective and how we looked at it, and try to make sure that we looked at patents as business assets more than anything else. So with that, I'll get started. So this will be interactive, ask questions as I go along. Let me start off by asking you a question. How many people are familiar with the patent process? Do you have patents in your name? Maybe you were involved with companies that filed patents. Just raise your hand. Okay, looks like, you know, maybe 30% of you or so. So good, that gives me an idea about where we are. So first thing I'm going to start off with is what is a patent? Well, a lot of people might think it's an expensive piece of government-granted mumbo-jumbo. And this is the front sheet of a patent, and you can see that might describe it pretty well. It has a lot of letters, it has some numbers right here, has a bunch of names here, got some code here, some more numbers down here, big list of things that you have to read. Even has some Latin et al. Up here. So yeah, it is. Point being, this is a complicated piece. This is a complicated document. It's made up of a specification, two main parts, specification and claims. And that's not shown here, and that's what's behind it. But a specification is the how-to part. It teaches people how to practice your invention, lets somebody who's skilled in the art understand what it is. It's a very important part of the patent. If you don't do that well, that can invalidate your patent. The patent concludes with claims. You can't really see it here. You can see it on your handouts maybe. This refers to 55 claims. That's the legal boundaries of your patents. And if somebody's suing it, that's what you're going to sue them on, is they are infringing those claims. Again, very important piece of the patent. It needs to be done well. It needs to have the proper scope, make sure your patent's broad enough, but it also can't be so broad it reads on what's disclosed here, which is called prior art, which would invalidate your patent. And one other point I'm going to make is, here's a list of inventors, and there's about 5 of them up here. And you see, again, I'm going to kind of talk about 55 claims. These 5 inventors, they might not have had inventive contribution to all 55 claims. They may have invented just one claim. But a patent is a joint owner. You're a joint owner. If you're an inventor, you're a joint owner of everything in that patent. So even though you might have only contributed to one claim, you own all 55 of those claims. So it's very important as you go about it and you're working with your vendors, your consultants, and the people that work with you, is that you get assignments from every single one of them to you of their patent rights. And both Brian and David will talk a little bit more about that as we go further. All right, so that's one possibility. What else is a patent? It could be a bragging rights at the bar of any engineering conference. So you see here a bunch of engineers enjoying a beer talking about the patents they got. And the reason I mention this is I think this guy invented how to swing on a swing for if you're 4 years old. I think this guy invented how to patent fantasy football strategies. So point being is that, hey, you know, you can get some things that aren't really that valuable, but it's something to talk about at the bar afterwards. All right, what else could it be? Well, it's the right to sue a thieving competitor. In other words, you have somebody who infringes your patent. The reason I'm bringing this up is patents don't give you the right to practice your invention. It gives you the right to prevent somebody else from practicing your invention. All right, so that's, and if you've done things correctly, and this kind of gets to the point of my, one of the main points of my presentation, is if you have a competitor, you have an infringer, you've actually maybe done something right. You've patented something valuable enough that a competitor goes, that's pretty cool, I want to do that, rather than invent around it. All right, so you've patented something that's commercially relevant, and we're going to talk more about that as we go forward. What else could a patent be? Well, it could be, hopefully it's a valuable business asset. That's what we tried to do at Energizer, is get patents that ended up being valuable to the company. The government, United States government valued intellectual property as $5 trillion of our $15 trillion economy. So they are indeed valuable if you do things the right way. All right, so the answer to the question, what is a patent? It's all of the above. They are all expensive pieces of government-issued mumbo-jumbo, complicated documents. Some, if you don't do it right, are just useful to brag about with your friends over a beer. But what we really want them to do, what we really want to shoot for, is make them be a valuable business asset. And how do you do that? Well, yes?
Could you define what it is to practice your patent?
Yeah, so remember I talked about the claims? So that's going to describe the scope of your invention. It's a chair with 5 legs, for example. Let's say that's an absurd name of or absurd claim. All right, so somebody else comes out with that 5-legged chair, or maybe he has 6 legs, but you've written it so it covers 5 and up. All right, that guy would be practicing your invention. He'd be practicing what you've claimed in your invention. Okay? Yes, sir.
So out of the 55 that are on that patent, if I was to just copy one of those, would I still be walking on that man's toes as well?
Yes, yes. In fact, what you do, and you talk about patent strategy, is you start broad, and you kind of, it's almost an inverted pyramid. You go down to narrower and narrower. And so you might assert only one claim out of those 55, all right? And the reason you do that is what you want to do is, you saw that prior art that was out there. And there's also prior art that you might not have found. And so you go through that, if you've crafted your patent in that inverted pyramid going from broad to narrow, you know, that broad claim might be invalid over some prior art you weren't aware of, but that little piece down at the bottom of the pyramid, that might be still be patentable.
I guess another part of that question would be, so there's 15 of these widgets that are out there, and they're made by different companies, but they all do the same thing. Like, take, for example, a television.
Yes.
And each one of those televisions has a different patent. How do they
Right.
do that? How do you here you're building the same thing.
Right.
How do you get around everybody else's patent?
Well, you've been able to figure out how to do it in a slightly different way. You've paid attention. You've got a really good patent attorney where you've gone, hey, these are the patents that are out there. How do I do the same thing? Okay, all right. And that's a very good question, because it leads me into my next slide, which is what you really want to focus on in order to make it a valuable business asset. You want to have your patent cover the commercially relevant benefit. In other words, you want to have a business-focused patent strategy. You want to look at, all right, it's just not, I just don't want to get excited about what my engineer did, and it's really exciting, and hopefully you got some smart engineers working for you. But you want to make sure that when you go to your patent attorney, you want to make sure he understands, yes, to your point, I want to make sure that nobody can make this TV in this particular way, because everyone's going to love, this is going to be a better TV than anybody else because it has provides this particular benefit that's never been done before. I want to cover it in as many ways possible. Okay, so you want to know, how you do that is you want to understand your invention, how it benefits your competition. You want to understand your customers. You want to understand your markets. You want to understand your competition and what kind of technology they have. What are they using? Is it close to the technology you're using? So when you come out with your invention, your new TV, he's going to go, hey, I know how he did it, and I can tweak it this way and get around it and start selling a competitive TV. So also you want to look at what you do differently than your competitor, and does it give you a competitive advantage? And if it does, how do you protect that? Because you want to hold on to that as long as possible. And I got some slides at the end that hopefully will emphasize that and show how that's done. Okay, so real briefly, what can you patent? Well, it's basically anything made by man up until some recent Supreme Court decisions, but it has to be useful, new, and not obvious, any product or process. It can also be ornamental designs. I'm showing the Apple iPhone here because in addition to all the technology that Apple included in their iPhone that made it such a great phone and all the stuff they patented, they also patented the way these tiles and the squares look on their phone. They recognize that's going to be beneficial to the customers. People are going to like the way they do it. And they were absolutely right because Samsung copied those tiles, and Apple sued them on the design as well as all the other innards of the patents, and Apple won a judgment of $500 million. So again, Apple recognized the way these tiles look, you know, that's valuable to the customer. I'm going to protect that the way they look. Samsung said, yep, they are pretty good. They didn't design different tiles. They went with the same thing and ended up having to pay on the hook for $500 million. Some of the things you can't patent. There's a couple recent Supreme Court decisions in this area that are very important. Are abstract ideas like a mathematical principle. That comes up in the software area a lot right now, and there's a lot of debate about just what you can patent and what you can't patent in the software area. Also, law of nature, naturally occurring phenomena, like this guy, okay? And one of the Supreme Court cases you may have heard of was Myriad Genetics, where Myriad Genetics spent millions of dollars figuring out a DNA sequence that was a marker for breast cancer, patented that, made a lot of money commercially, fought some patent infringement suits, and the Supreme Court said, listen, you can't patent that sequence. That's naturally occurring. It's out there already, and you can't patent. That is not eligible for being patented. Okay. So how do you get a patent? You got to call a patent attorney, all right? In my opinion, this is not a do-it-yourself project, okay? We talked about remember the patent in the front, the big government piece of mumbo jumbo, specification being very critical. How do you describe how you make and use that invention? You talk about the claims. You want that scope to be as broad as possible, but also as precise as possible to avoid your prior art, okay? But how do you turn it into a valuable business asset? This is a joint process. It is not something that you just call up your patent attorney and say, hey, I got a great idea. Can you patent this? And then a couple years later, he goes, hey, look, I got this patent. It's a collaborative, joint effort. You want to work with them throughout. You bring with him, what you bring to him is knowledge of your business. You got to drive home, this is the commercially relevant piece. This is why this particular invention on the TV is more important, and you got to make sure you're going to cover that. Your engineers are involved, okay, because they're the ones that are making that. You're making that invention. Yes, sir.
Well, what's the benefit then of the poor man's patent?
I don't know what the poor man's patent is.
Oh, it's a concept that if you were to email yourself and never open up the email, whatever your idea was, that it's in a sense put in a timestamp on when you came up with that idea.
That's a very good question. It's not very valuable at all, okay? Because the point of patenting is, the government's going to give you this 20-year right in exchange for you telling the public about your great idea. Okay, the purpose of the patent system is actually to foster creativity, to foster people going, that is a great idea about how to make that new TV. I got a better idea. And that's how the system progresses. So if you mail that idea and stick it in your drawer, you're not offering the public what you're supposed to offer in order to get your exclusive rights. Okay?
I just a point of clarification, which is with a recent change in the U.S. patent law, it used to be the first person to produce it. Now it's the first person that actually patents it now as the legal right.
That's a good question. I think either Dave or Brian are going to cover that in more detail. But I'll comment a little bit. It used to be that the U.S. was what's called a first to invent. Okay, so that to your point, the poor man's patent dated, have somebody witness it. Okay, if you subsequently then went and filed a patent application, and somebody else at the same time had filed an application on the same invention, previously that particular piece of evidence you might have been able to use to win a judgment to say you were the first to invent, so you're entitled to the patent. The laws.
That would have been at the laser win a few $billion.
So, but the law has been changed. Now it's first to file. So in that same particular situation, you've mailed it to yourself, put it in the drawer, but that other guy beat you to the patent office. Now he's going to win. Okay. So, very good questions. Good. So again, let me just summarize. It's collaborative effort. You bring the knowledge of the business, what's commercially relevant. Your patent attorney is going to help you navigate all the ins and outs in the patent office. Your engineer is going to be working, going, yeah, this is how you talk about it. This is the really cool technological advance. All three of you together are going to end up making sure you have a valuable business asset as opposed to something not so much. Sure.
Made me think here, which I guess is good. How would you recommend we go about evaluating a patent attorney? I mean, I feel like there's so many different options, right?
Good. Yeah, good question. There's a slide toward the end that addresses that. Okay? We'll talk about that. All right, I'm going to talk a little bit about cost. This little slide shows you, got costs on the left, but patents are money and time. These are attorney and agent billing costs. This isn't filing costs. So when you file a patent at the patent office charges you a fee. If you're a micro entity, it's about $400. Energizer, if you're a bigger company, they make you pay more. It was like $1,600 for us. And then there's maintenance fees as you go on throughout the life of the patent. But as you see here, that adds up to about $15,000 total. I would say on the software and biotech side, it's probably going to be double that. All right, those areas are very complex, very complicated, very crowded, also very profitable. But again, so that's why the reason for it costing more. I also want to point out here, years 2 and 3, and right here, review and respond to the patent office's objections. So once you file at the patent office, the examiner is going to look at it. They're going to send you a letter saying you're not entitled to your patent for a couple different reasons. Here's some prior art. You didn't write it correctly, et cetera. And so that happens about after 2, maybe 3 years. So again, when I told you this is a collaborative process, your business might have changed quite a bit in those 2 or 3 years. So now you got a communication from the patent office saying, hey, you're not entitled to your patent for these reasons. You want to make sure that when your attorney gets ready to respond to that, you've gone to your attorney and go, hey, just so you know, my business has changed a little bit. Here's the commercially relevant benefit now. Make sure that you keep sight of that, because over time that might change. All right. So you've done everything right. You spent the money, you spent the time, you got a patent and it's a value, and you've captured the commercially relevant benefit, and you have an infringer, a thieving competitor. What do? It's a big question. Your options basically are to sue or maybe license. You want to decide what's best for your business. Is this something that you absolutely can't let your competitor use? Well, you might have to sue him. All right, it's a bet the business event. You might have to sue him. Can you exist with your competitor? Maybe your technology's moved on. Maybe he's using the previous generation, and you're just fine charging him a fee. Okay, that's an option. Also, he might have some technology and patents that you want. And so you might be able to trade with him. And so you both have improved your technological, proficiencies that helps you compete with them, better as well. You had a question or you had a thought? Go ahead. No, pause it.
So what if the thieving competitor, I don't know how likely it would be, but it's a really big company, right?
Right.
It's like, it'd be kind of weird. I'm going to go sue one of them. It's like they could drown me. It's
Right.
lawyers.
Right.
So what do you recommend?
Well, actually, go ahead. So he was talking about, he's got a great idea, but he's just, I'm sorry, what's your name?
Scott.
He's just Scott sitting in the front row, all right? And Apple goes, hey, I want to infringe that patent. How's he going to fight Apple? All right? There are a couple different ways, I guess in a sense.
I'm not, as you say it,
Yeah.
it's like, how likely are they going to do something like that?
Well, it's a big worry, and this is why you're getting the patent. You're spending the $25,000. You're spending the effort. You want to make sure that you have an opportunity to fight Apple if Apple's the guy. So there's a couple different options. You find some patent law firms that take it on a contingency basis. You can find some patent law firms. You can actually find some people that will actually fund the litigation now. There's also a really good product and a group here in town. Brian's with the law firm Harness, Dickey & Pierce, and they do work with an insurance company called AHM. And you can actually buy patent infringement insurance. okay? And so they will cover the cost, so that enables you to go after an Apple or somebody else. Okay? Yeah, Jane?
I was also given advice
Yes.
to lie quietly in the weeds and wait until they turn a profit and then you can collect royalties. Is that also an option?
Well, yeah, kind of. What the risk you kind of take by laying in the weeds is some legal legal doctrines you want to worry about called latches. You sat on your rights, and the law doesn't like. These are equitable doctrines. If you sat on your rights, the law won't let you enforce them, as well as estoppel. In other words, have you done something to indicate to the infringer that you're not going to pursue them? Okay, so it is kind of, it might fit into your strategy. That's something you want to talk to your patent attorney about again. So, it's a big plug for patent attorneys, but this is big stuff. So, it is worth your dime. Yes, sir. Oh, sorry. In the back first, and then we'll come in front. Yeah.
Is there a way to protect patents in an LLC from co-owners and partners?
Yes, you need assignments from them. Those are agreements. I don't know what you mean by protect against, but
If the LLC breaks up or if
Right.
co-owners leave, come and
Right.
go.
right. I think Dave's going to cover that in more detail, but you need agreements with everybody that's involved in that LLC that they're going to assign their rights to that invention to the LLC. So when they leave, the LLC still owns it. Doesn't matter what they're doing. And that's a big risk because a lot of small companies, that ends up being a big problem. They don't get those agreements. That guy leaves, all right? Then you have an infringer. The LLC wants to sue him, but because that guy left, that LLC is going to have problems bringing that lawsuit. Okay? Yes, sir.
Yeah. Would you be infringing on someone's patent if you are using that element or whatever it is for a purpose that it wasn't intended for? Like,
Yes.
You are. Okay.
Possibly. It's all based on what the claim says, and if what you're doing is covered by that claim, your intent doesn't matter. Okay? All right, so what's best for your business? So what's best for your business? Because I want to talk real briefly here about Tesla and Elon Musk and his all the patents he has on his electric vehicles. He's actually announced that he will not enforce his patents against infringers. All right, now he's made a decision, and I haven't talked to him, so I don't know what his reasons are. But one of the things he's done is he's also spending $2 billion building the world's largest lithium-ion battery plant. So one thing he might be thinking is, if I don't enforce my patents, I can get people to sit there and use that technology, develop vehicles that will use batteries that they'll buy from my company. Okay, so that may be part of his thinking, but it's a business strategy is the reason I want to mention.
Actually, I read a white paper on that, the reason why he's doing it. He's wanting these other electric car companies to get together, put their minds together so
Right.
that these products can be sold built nicely and sold at a cheap price.
Right. So very good. So thank you for having that. A little bit more information on what Elon Musk is up to, but so. Oh, sorry.
It's all right. Does your operating agreement protect like the LLC situation you were talking about if one of the parties leaves? Because on your operating agreement for your business, isn't that where you outline what to do in the event somebody leaves or
Right.
it has an exit strategy?
Right. It does have an exit strategy, but every single time you need to have a separate agreement with each of the people that are going to be possibly inventing. And you need to say, listen, anything I come up with, I'm assigning to the LLC. You want that separately. Okay. All right, so you got that infringer. You're going to go after him. Here's a little bit of information about enforcing patents. As you can see up here, I got the number 2 million. A patent is good for 20 years from the date you file. The useful, kind of valuable life is probably in that 3 to 12 year range. So I went back, so I'm just kind of saying, so if you go back right now, past 10 years, probably 2 million patents are in that useful life, all right? In 2012, there were only 140 patent infringement trials, okay? So you can say, well, there's not very many trials, despite the fact there are 2 million patents out there. There are about 5,000 new patent infringement suits filed each year. Okay, so you can say, well, geez, maybe patents aren't worth that much if only 140 are going to trial. Or you can say the system's working, all right, because if you do infringe, you're on the hook for $1 million. That's both if you're a plaintiff or defendant. And that's just, even if less than $1 million at stake, all right? And the cost obviously goes up when the amount at stake goes up, and if it's above 25 million, it's even more. Okay, so you can say the system works. A lot of people doing a lot of work to avoid being on the hook for this. And I'm going to mention a little bit too. I think that a lot of the work you guys do, and you're coming here and you're thinking about the patent process and what I need to do to make sure I get patents. But one of the things you want to talk to your patent attorney about is, wait, is what I'm doing, am I infringing somebody else's patent? Ask him about a freedom to use study. That's a separate activity than a patent. It costs some money to do, but it'd be worthwhile so you don't end up on this end of the stick. All right? Yes, sir.
At what point in this process is the patent actually published?
The patent will publish, so when you file it, the patent will publish 18 months after you file it. Even if it's not been granted, yes. And as soon as you file it, you can put a patent pending on your, you can put patent pending on your product, and that's it. Yes, sir.
What is the average cost for freedom activities?
I'm sorry?
The average cost for freedom activities, the fee, average fee.
For
freedom activities.
For infringement activities?
Yeah,
That-
let's say there are some patent is expired, okay?
Yes.
But they add some kind of new thing. I'm not sure whether I can have rights, to use this technology.
The average cost for freedom to use opinion. Yeah, that's going to be, and it depends upon how complicated it is, but you're looking at maybe 10,000 and on up for that, okay, as well. All right, and the last bit of time I have remaining, I thought I'd talk a little bit about examples from my experience at Energizer, hopefully a really good example of commercially relevant patenting. So when people find out I spent 25 years at Energizer, they all want to talk about the same thing. That's razors. So I don't know if you know, but Energizer bought Schick Shaving about 10 years ago. Their biggest competitor is Gillette. In 1998, Gillette introduced the Mach 3 razor, which was a very, very good razor. Very smooth, comfortable, close shave, and you didn't end up with all the nicks and cuts, that typically you ended up with shaving back at that time, which I was, believe it or not. So what did Schick do to launch the Mach 3? They spent $750 million in making that shave. It's not as easy as what you think, all right? And they patented, about 50 patents on every aspect of it. How the blade sat in the cartridge, and the guard bar, the lube strip, and I could geek out all day about the technology that goes into shaving, it'd probably bore everybody. Okay. They also, and believe it or not, it still is the largest men's shaving brand. In 2012, it had like 13% of the market, larger than Gillette's Fusion brand, their 5-bladed razor. So you see what a great shave it was, what a great invention it was, and the benefit of this $300 million investment in advertising and marketing. A lot of it was giving handles away to men of shaving age. All right, in the shaving business, that's what you do. You send handles out, you make your money because they go and buy the cartridges. All right, and that's a large part of that 300 million was that. All right, but that's a great idea, but there's a gap in that model. By Gillette sending out all those handles, they basically installing a user base that a competitor could exploit. The competitor can go, hey, I can make a shave that's not quite as good. I can design around, to your point, I don't need to have the right geometry. I don't need to have the guard bar or whatever, but I can make a cartridge and sell it at a fraction of the cost, and it'll fit right on that handle that Gillette is so nicely, for me, installed in a men's medicine cabinet. All right? So what did Gillette do to convince the CFO and the CEO that spending $300 million to send out handles was a good idea? All right. Well, they had somebody there was a smart guy, is probably a patent attorney. He patented the way the cartridge fit on the handle. All right. And it's shown right here. And so what this did, was this advertised? Was it part of any of their advertising? Hey, we got this really cool way it fits on the handle. Was that something that the man shaving goes, "Mo, I really love the Mach 3 because it fits on the handle like this"? All right, no, they didn't do that. And not only that, all those other 50 patents on how many blades, the geometry and stuff, it didn't prevent competitors from coming out with their own 3-bladed razor. Schick came out with a 4-bladed razor that we were sued on by Gillette on this Mach 3, some of the Mach 3 patents. But nobody was able to make a cartridge that would fit on the handle. And that had protected that billion-dollar investment to the point of even up to a couple years ago, it was still the world's largest shaving brand, men's shaving brand. Okay, so to me, that's a very, very excellent example of recognizing where the commercial relevance was. There's a gap in our commercial plan. Let's fill it. Let's use a patent to fill it. Yes, sir.
How granular does that get? For example, if a clone manufacturer was to say, "I'm going to add a nanometer to every single dimension on that clone."
It was well. I mean, it was a very good patent, and just little. When we Gillette. It was not that granular, to answer your question. Okay, it had to do with how the different pieces were arranged. And it was very, 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 very broad. They did a very good job of patenting to prevent exactly that. So back to your question, what do I look for in a patent attorney? Well, you want to ask, what their technical background is. If you're in the software business, get a guy with software experience. Bio, get a guy with bio experience. All right. How many patent applications have they written and prosecuted to allowance? And do they have any familiarity? The law has changed. There's this new process where patents can be challenged right after their grant. Brand new process in the U.S. Do they have any experience in that? Have they been successful there? Have any of their patents been involved in litigation or licensing that they've kind of wrestled with? So they're knowledgeable about those issues. Are they knowledgeable about your business, the competition and technology? All right, my final slide. There are some processes that you should have in place to make sure that, oh, sorry.
So you can go back to that.
Yeah.
It's a lot of comments.
Oh, I can't.
It's fun.
Okay. Sorry.
So if you're shopping around for furniture,
Yes.
to look at, let's say, you explain the idea or whatever, and then you find out, oh, they don't have the background, or it's not a good fit, whatever.
Uh-huh.
We don't need to worry about anything, and it's probably a dumb question. We don't need to worry about them sharing things, depending if you have no protection on this thing anyway.
Mhm.
So I just noticed, like today, I was meeting with a couple of IP attorneys, and talking to the idea and all that stuff.
Right.
It was just like, and I saw them taking the notes and stuff like that. But I also didn't have them sign anything where
Right.
So how does that work?
Um,
I'm not trying to say they would, but.
oh,
He's talking about non-disclosure.
Yeah,
Are
Right,
they gonna,
right.
Is he protected at
I
all?
like to give people
Yes.
their feedback, right?
yeah, you can talk to attorneys. We are obligated,
So they'd be disbar, obviously.
Yes.
Okay.
Yeah.
I know it's a dumb question.
No, it's not a dumb question. It's not a dumb question. I come across it with people. They go, "Hey, sign my confidentiality agreement." I go, "Hey, I'm an attorney. I'm going to give you the. I will lose my license if I violate this." But it is something to be sensitive about. I mean, so it's good to be sensitive, and it ties me into the last slide because NDAs and confidentiality agreements. If you don't have those in place, use those aggressively. I think Brian and David are going to talk more about those. If you don't have those in place, you can basically be considered of giving your patent up. You've given it out to the public. Remember, I told you that's the exchange for getting the patent is letting the public have it. But if you've told people the idea without having those confidentiality agreements in place, you might lose your patent. And then also, again, to your point, get agreements with everybody involved in the invention process. If you don't have an agreement with the guy that invented Claim 54 or that 55 claim patent, he can go out and give those rights to your competitor if you're not careful. So.
Do you have examples of what those agreements would look like, or is this stuff online?
Actually, Mr. Jennings does. So anyway, yes.
I was going to say, I'm a little bit of an age, and I remember back in the days when electronics were very simple, and I've noticed with technology getting more and more advanced, patents are getting more and more hard to write up and stuff
Right, right, right. It is getting more crowded. There's 2 million, patents out there. There's 200,000 grant every year. But there's an interesting quote back. Abraham Lincoln's the guy that had the patent office back when Abraham Lincoln was president said, "Hey, everything's been invented. There's nothing for me to do here." So times change, and technology opens up. That's really the beauty of the system, in my view. All right, is that in exchange for giving you those exclusive rights, you have to disclose fully what you've invented. It actually triggers new ideas by everybody else, and that's how it advances. So, anyway. A couple more questions? Yeah.
Hey, could you give a short 30-second difference between a utility or use patent and a design patent?
Yes, probably less than 30 seconds. But utility is how something works. That's a new product or process. Design is how that product might look. Okay, the ornamental design of it. Good?
I want to ask about the international patent pending. If I have a patent pending in some other countries, and I make a product and I want to sell it here in the US, then somebody copied it.
Mm-hmm.
Do I have any protections or any other thing? Because it's not yet fully patented in any other
Right.
countries, just patent pending.
Your patents are geographic in scope, all right? So even though you might have a patent in the US and then you try and sell it in China, if you haven't patented in China, you can't enforce it in China. And then vice versa. So you've filed your patent application in one of the European countries, but you haven't gone and done the same thing and filed here, you cannot pursue an infringer in the United States. You'd have to pursue them for whatever activity occurred in the geography in that country in which you have your patent granted. Good?
So is there any system that can give me a whole world patent?
It's called the PCT, okay? And that's something to talk to your patent attorney about. Is like, hey, this is just not a U.S. activity. I'm going to take it out on the globe. So how do I protect it globally? And he'll probably talk to you about what's called the PCT.
That kind of answers my question.
Okay.
What would you do to protect like a recipe like Coca-Cola? You're talking about public disclosure. Coca-Cola definitely wants to keep that all secret.
Right. That's another piece of intellectual property called a trade secret, and they've protected that very well. And I think Brian and David are both going to touch on that a little bit more. Okay? Good. All right, thanks a lot, everybody.